Welcome, everyone. Thank you for joining us. We appreciate you taking your time out of your busy schedule. We're going to go ahead and start our webinar on the Corporate Transparency Act. And I'll mention that we have the chat option open if you want to ask any questions, or we'll try to answer those as we go, or either at the end. And if we run out of time, we'll follow up with emails to you guys. But I want to go ahead and get started and introduce Angela. She's going to be the main presenter for this webinar on the Corporate Transparency Act, which of course has gotten a lot of news lately and will be coming. The law will go in place on January 1st, whether we like it or not. So we might as well learn the requirements and figure out what we need to do to comply with this law. But I'm going to introduce Angela. Angela Baldwin is with our firm and a great corporate attorney, estate planning attorney. She does a lot of transactional work. She's up to date on all the provisions with the Corporate Transparency Act, at least as far as they've released regulations to date. Angela went to undergrad school at Clemson, where she graduated with honors, and then went on to Duke Law School, where she received her law degree and also received her master's in business administration. So we're excited to have Angela here. I'm going to go ahead, Angela, let you jump in and take over. And again, I should introduce myself.
Yes.
Sorry, I'm Sandy Clark, by the way. I play less of an important role in this webinar, but we'll be joining Angela also.
Thank you, Sandy. First, thank you everyone for joining us here today. As Sandy said, this law will be enacted, or not be enacted, but be effective January 1st. And as much as everyone is a little scared about it, if you already know about it, we can't do anything about it. So we need to learn as much as we can and be prepared to be in compliance with this law. So just some background about what we're going to talk about today. I'm going to talk about the Corporate Transparency Act, or the CTA as you'll come to know it as. Get my presentation. There we go. And so in 2021, Congress enacted this act. And what it does is it now requires certain companies to submit certain reports to FinCEN, which is the Financial Crimes Enforcement Network. They enacted this act in order to combat certain crimes that we've all heard about: money laundering, tax evasion, all those crimes where people hide money in shell corporations, all that stuff. And they want to promote transparency regarding the ownership of any businesses that are doing business in the U.S. So
I should mention, Angela, we're in Europe and other countries, this laws or similar laws have already been in place for years. So the United States felt they were behind on some of the transparency of entities as compared to some of the foreign entities. And while this feels like a burden that's uncomfortable and unusual to most United States people, we don't want to give Social Security numbers and date of births. It's commonplace if you're dealing with an international company.
Yeah, so today we're going to talk about who this act applies to, who is exempted from this act, also what information will need to be reported, as Sandy just prefaced, some very personal information like Social Security numbers, birthdays, and we'll talk about who, because not all people who have ownership interests in companies will need to report information, but we'll talk about who will and what information they'll need to report, and then we'll also talk about the how and when of those reports. So first, who has to report? So if your company is a entity that had to file any document to the Secretary of State or a similar type of governmental entity in order to register to do business or create the company or form the company, you are likely in the bucket of companies that will need to submit reports to FinCEN next year. So that does not include sole proprietorships or foreign companies that do not do business in America or register to do business in America, but it does include corporations, limited liability companies, limited partnerships, or other foreign companies who are registered to do business here. Yeah. Anything there, Sandy?
No, it's estimated that it affects 32 million entities, so not small by any means.
Yeah, and FinCEN probably is not ready for this. They'll have to be able to answer calls and questions regarding all of those entities. And we also want to preface by they're still making certain decisions regarding this act. Even today, we have a couple weeks before it's effective. So there are still some things there are some gray areas, some vague provisions going on, but we're going to keep up to date on what's going on and also keep you all updated as we learn more.
Right, and just to answer one chat question, they have recently extended the deadlines for new corporations starting after January 1st, and we'll get into those deadlines. But keep in mind, the January 1st deadline is when the law goes into place, and that's not been delayed or revoked or moved. It's the reporting requirements. So starting January 1st, this law becomes in place, and we start to recognize it. There's some timing elements that Angela's going to get into that require when the reporting is, but January 1st is our start point for this law.
Yeah. So as far as who does not have to report, there are 23 types of entities who are exempted from the report. So if you see your type of company listed here, you likely don't have to file a report, but feel free to contact us to confirm that. So these types of entities are usually entities that are already heavily regulated by the U.S. So the government already has a means to determine the owners of the company. They already have insight into the business of the company and all of that. So these are publicly traded companies. These are just some examples: banks, insurance companies, nonprofits, large operating companies with at least 20 full-time employees, $5 million in annual revenue in a U.S. physical location, and also inactive entities formed before January 1st, 2020 that are not engaged in active business, are not owned by a foreign person, have not experienced any change in ownership in the previous 12 months, have not sent or received funds in the amount of $1,000 or greater in the previous 12 months, and does not otherwise hold any type of assets. And that includes ownership interest, so it can't be a parent company or real estate. Even if it passively owns real estate, it is not an active company. And you probably, if you have an active company that applies to these specific criteria, you probably should think about dissolving that entity. And that's also something I would recommend calling us about to figure out that might be easier, just to make you feel more at peace about whether or not you need to comply with this act.
Yeah, that's good. Yeah, the inactive entity is going to be very limited. It's almost going to be someone just trying to save a name, because even if you have any real estate or any investment asset at all, you'd be subject to the filings.
As far as reporting requirements, so we've talked about who does and does not have to file reports. Now we're going to get into which people you have to start collecting information about to submit reports, and also what information needs to be collected. So reporting requirements, starting on January 1st, most companies will need to start collecting information regarding their beneficial owners and their company applicants. So we're going to talk about who those people are. Beneficial owners are people who own or control a company. So they directly or indirectly own or control 25% or more of the ownership interest of an entity, or exercise substantial control over the entity. So those are kind of vague, especially the second item. So we're going to talk about that a little bit more. So as far as directly or indirectly owned, it's not as simple as saying, hey, I'm a shareholder, I have 25% ownership interest in this company. It can also be, I have a convertible promissory note that says I have the rights to own this company. I have an option to own this amount of membership interest in this company. So it's not simply as I'm on the operating agreement, I'm on the shareholders agreement. It's also options to do so. And then as far as the second prong, people who exercise substantial control over the company. So these are senior officers, presidents, CFOs, chief executives, people who have the appointment or removal authority to remove senior officers, and other important decision makers in the business. So managers, all those people who direct the day-to-day of a company. This does not necessarily include board of directors or like a partnership representative or a tax matter partners. Those types of people will be determined on a case-by-case basis. But if you're simply an agent of the company, it doesn't count. It's people who have substantial control over the company's direction and their operations.
And I think one of the keys is the substantial control at least the regs that are out now, states they're involved with important matters, which is very broad. Um, likely includes your decision makers of the company, which could be officers that may not be owners. Um,
And then company applicants. So this only applies to companies that are formed January 1st, 2024 or afterwards. They'll need to submit information regarding their company applicants. And those are the people who directly file the document that creates or registers the company. So the articles of organization or the articles of incorporation, and also the people that directs or controls that filing by another person if more than one person was involved. So for example, if you hire our firm in order to file your our articles of organization or articles of incorporation, we'll have to provide our information to FinCEN and also yours. But there is a two-person limit. So depending on our office and how we are directing the filing, it might be two people on staff here at our firm that will be included on your report.
so I think the days of just going on the Secretary of State website and filing articles and thinking you're done, those days are over, at least for reporting in compliance with the Corporate Transparency Act. So clients would need to get involved with either someone that's going to take the responsibility to make sure that they've filed according to the FinCEN requirements.
So now that we've talked about what people will need to start collecting information about, we'll talk about what info we'll need regarding those people. So we'll need their full names, their date of births, their addresses. So for beneficial owners, it would be the residential address. Again, that's officers, senior officers, people who are in control, people who own 25% or more directly or indirectly of a company. And then also for company applicants, it's a little different. For company applicants that work in corporate formation, such as our firm, it would be our business address. For other company applicants, it would be their residential address. And then also, you'll need to provide copies of some type of governmental identification, such as a passport or a driver's license, and then include that information in the report. So in some instances, a reporting company can report a parent's company name in lieu of information about its beneficial owners. If their beneficial owners only hold their ownership interest in the reporting company through the parent company, and the parent company is an exempt entity. So we'll probably get a lot into drawing charts to figure out what information needs to be collected, who needs to collect the information in order to make sure that's organized and effective, and making sure that all the information we need to report is reported. And also we're making it simpler for our clients who don't want to provide too much information.
Again, it's adding a step that's awkward for at least our clients. I know when we normally don't start off the bat asking for date of birth, social security numbers. I need a copy of your driver's license. So it's going to be an awkward situation. Keep in mind for the addresses also for the beneficial owners, you cannot use the law firm addresses. You have to use their actual resident address, which again, some of our clients like their mail and deliveries to go through. Different addresses or PO boxes, you need to really use their physical address in this situation.
So that's the information that will need to be reported about individuals. So for reporting companies, it's a little different. We'll need to report legal names of the companies, any trade names, so that's DBAs, the address of the principal place of business. Again, this cannot be a PO box. It'll need to be their actual address, the jurisdiction of formation or registration, and then their EIN or similar tax ID number. And so every non-exempt reporting company must file its own report. So let's say a parent company has 20 affiliated companies. It can't file one report to cover all those companies. Each company will need to file its own separate report. To simplify this a bit, to also, because many people won't want to give all their vital information to the companies that they are shareholders of, members of, depending on their relationship with the company. The FinCEN has provided what are called FinCEN identifiers. There will be an application that we can submit on January 1st asking for these. So what it is basically an identifying number that can be used for individuals or reporting companies instead of providing all of your personal information to the reporting companies. So there are some caveats for entities of when they can use this. but it will be the same. You'll provide the same personal information that you would in place of providing it to the reporting company in order to get your identifier, but it will lessen the burden for initial reporting and updates like address changes and all of that for the reporting company. So to make it easier on all parties to go ahead and get that number.
And Angela, I think one thing that is important to remember is this the corporation's obligation to provide this information? So you can imagine a corporation that has several individuals in control, and you may not know when someone's moved or, you know, when they've changed their home address. So the FinCEN identifier, I think, is going to be a big helpful thing for individuals. Plus, it might be that if you're involved with several entities, the one-time filing makes things simpler. And also if a client or one of the beneficial owners is hesitant to provide their information to the corporation, then they could set up their own FinCEN identifier and just give the FinCEN identifier number, which may lessen their awkwardness on providing that information possibly.
Yes. And also just make it much safer for everyone involved. So we've talked about the what and the who. Now we're going to talk about the how and the when. So reports are not being accepted until January 1st. What's a bit difficult is that the report has not been made public yet. So we're not even able to see exactly what the report looks like just yet. But we're all expected to start being able to submit these reports on January 1st. So for as far as deadlines, they're a bit different depending on when the company was formed. So for all companies that are created or registered prior to January 1st of 2024, so just in a couple of weeks, we'll have until the end of next year, so January 1st of 2025 to report. So if your company is already in existence, we have about a year to file your report. Of course, we'll still want to be proactive, but we have some time. For companies created on or after January 1st, there's a 90-day deadline. So for companies created on January 1st, we have until about April 1st in order to submit those reports. So as far as created or registered, what day is your company created or registered? It's not the day we submit the articles of organization or the articles of incorporation necessarily. It's the day that we receive notice or is publicly available information from the Secretary of State that this company has been registered. And so that's next year. At first, the deadline was 30 days for new entities. Again, this is for new entities only. There's a 90-day deadline. It was 30 days because the FinCEN recognizes they're not ready for the influx of applications that are coming in. We're also not ready because they haven't provided all the information we need. Because of that, there's a bit of a grace period. So now there's 90 days, but after next year, the deadline will go back to 30 days. So for companies created or registered on or after January 1st of 2025, the deadline will be 30 days. And any updates or corrections to beneficial ownership information that was previously reported must be submitted within 30 days. So there's an address change, a license number change, any of that information changes, you'll have to provide updates to FinCEN regarding that. So you'll also need to provide corrected reports. So if, let's say, a beneficial owner gives you their wrong address or their wrong social security number somehow, you'll have to correct those within 30 days. If there are any changes, such as a business changes its name, someone sells their ownership interest, let's say I own 25% of a company and I sell that to Sandy, we'll need to update that change. Any change to the beneficial owner's information, including their name, address, or ID number will need to be changed. And you have 30 days to submit those reports.
Again, I think this is where the FinCEN identifier is going to be key. Because really every time you renew your license, every time you move, every time you issue new stock and create a new owner that now has met the 25% threshold, every time you hire a new CFO that now has substantial control over your business, you would have to modify your report. Whereas if you get a FinCEN identifier, if those individuals haven't changed, you can just rely on the individual updating their FinCEN identifier information, and then the corporation would just worry about if individuals names have changed as far as ownership or substantial control individuals. And again, with the burden being on the corporation and the fine and penalties being on the corporation, corporations are going to have to make sure the individuals that are supposed to be reporting this stuff correctly are doing that. So I think the FinCEN identifier is going to be, as people gradually get involved with this act, are going to be key to being able to stay in compliance without so much of a burden.
And then also, I want to make it clear that there are no annual reports. So we'll have our initial report that we'll make, and then updated reports and corrected reports. But there's no, we have to do this every month, every year report, thank God. And we don't need to provide updates regarding company applicants. So if you remember, we'll be providing information regarding beneficial owners and company applicants in the initial report. But if for some reason your company applicant is no longer affiliated with the company, there's no reason to update them. We can't remove them from the report, anything like that. We also don't need to report when the type of ownership interest changes. So if we reported in the past that you have an option to purchase interest in a company, and then you do purchase that interest and nothing changes about the amount or anything like that, there's no need to update as long as the information is already on record. And then, so now we've heard about the what, the who, the when, and the how. So what happens if you don't submit these reports? There are some severe penalties for willfully violating the reporting requirements, and those include civil penalties of up to $500 a day, and then also criminal penalties of up to 2 years imprisonment and a fine of up to $10,000. So these are violations for willfully failing to file a report, filing false information, failing to correct or update previously reported information. And both entities and individuals can be held liable. So including if you have a shareholder who is very difficult and does not want to provide the information, they can be held liable. But reporting companies are expected to gather this information. The burden is on them to verify this information to make sure it's true, complete, and correct from their beneficial owners and their company applicants. And they have a burden to implement mechanisms within their company to make sure that they are informed of changes. So we can't just leave it up to the shareholders and the members to always tell us what's going on. There probably should be a check-in by the company to the owners of the company. Hey, has your address changed? Has your ID changed? Maybe a monthly check-in, maybe a quarterly check-in, depending on the risk factor there. But FinCEN is expecting reporting companies to take on this burden.
So I think again, the corporations are going to have to be proactive in this, and you've hit on some of the questions that we don't have answers for yet. You know, who has that substantial control, whether it's the board of directors or just your owners or your CFO that's not even an owner, and probably erring on the side of over-reporting. There's no limit on the maximum amount of individuals you can report under FinCEN. It's probably better to err on the side of over-reporting, even though, again, individuals don't particularly like sharing this information. If they do use the FinCEN identifier, that might be an option that they're more comfortable with. But because the burden's on the corporation, willfully, just ignoring this is not going to be an acceptable way to practice in your business any longer because of the penalties, and that could be subjected and be even criminal penalties.
So now, what does this look like for us? So for businesses and even for estate planning, which Sandy will talk about a little bit in a minute, but things are going to change a lot. So as far as the burden is on reporting companies to get this information. So we're going to have to start being more proactive as far as talking to our shareholders and our members regarding their information and collecting this information and not waiting until the last minute. So while next year the deadline is 90 days for new entities, the year after that, like I said, it's 30 days. So we probably want to get into the habit of, before we even form a company, we're already contacting, if you are a multi-member or a multi-shareholder company, contacting everyone for their information and having that in hand as soon as possible, and not waiting until after the company is formed, because we don't know what will come up. And there doesn't seem to be any grace period for filing the day after the deadline or 2 days after the deadline. And also, we'll want to start implementing provisions in our governing documents, so in our trust agreements, in our shareholder agreements, in our operating agreements, requiring our members and our shareholders and our trustees and our beneficiaries to provide this information, even if it's just their FinCEN identifier, but putting the burden on them to apply for that FinCEN identifier and supplying that information. And we just want to be very careful about making sure things don't fall through the crack. So we'll need to talk about the ownership of the interest, how is the ownership of the business, how is the business ran, just to make sure we have enough information regarding the beneficial ownership of the company and the company applicants to file a true, complete, and correct copy of the report to FinCEN. As far as the estate planning, Sandy, do you want to speak there?
Yeah, and just to address one question in the chat, if you've incorporated, and let's assume the act was already in place, because the first year, of course, in 2024, we have this 90-day gap. But if you form a business on January 1st, in 2024, you have 90 days to report who the initial owners are. If you change ownership, even but during that time period, you'd have to, within 30 days of the change in ownership, file the information regarding the change of ownership. So if you start as a single member LLC, bring in a couple different partners, at the time that you bring in those new partners, there's a 30-day window at that time to file with the new ownership. I suspect during the first 3 months of 2024, all of those filing requirements are going to be delayed for the 90-day period. But after any change of ownership, there'd be a 30-day filing requirement. So again, a lot of people start out single member LLCs and then bring in investors throughout the year. If they meet the 25% requirement or substantial control requirement, there would have to be a new filing to update within 30 days. You mentioned, Angela, that how would this impact estate planning? So of course, with estate planning, we use a lot of trust. We use a lot of LLCs. The LLCs are going to follow the general format of any LLC that owns any asset's going to have to do filings, even if it's a disregarded entity in a single member LLC. That's not an exception, and they would have to do the filings. There is an exception for minors. So if we have, let's use the example, a trust owns an LLC. So you can't just report the trust owns it. You have to dig down in and get the beneficial owners of that trust, which could include a lot. So if I set up a revocable trust, and I have my children as beneficiaries, and we own an LLC, I have control over that trust. So I'd have substantial control. I'd have to have my information provided to FinCEN. Also, my children, if they're adult children, would have to file their information because they're beneficiaries. And in my example, they were more than 25% beneficial owners. And that's if they have a direct ownership. If I'm the only beneficiary during my lifetime, I would be the only one that would have to report because I'm both the substantial controller and substantial owner of that. But I would, even under a trust, I would have to report that information. If I were to pass away and then my children become beneficiaries, that's when they would have to, within 30 days, because there's now a change in beneficial owner of the LLC that the trust owns, they would have to update that information so that the beneficial owners would reflect my children after my passing. There's several questions of what happens. There is one exception for minors. So if, again, my children were minors in that example, I passed away and now they're beneficial owners, but it's held through a trust. The trustee certainly is going to have substantial control. So they're going to have to provide their FinCEN information. My minor child could avoid filing as long as I provide information either of a parent or a legal guardian. So you can delay filing this information for anyone under 18, but you do have to provide it for the legal guardian or the parent. There is an exception for a future interest. So again, in my example, while I'm living and I'm the beneficiary of my revocable trust, my children wouldn't have to report anything, and I wouldn't have to report their information because they're only a beneficial interest when I die. And that's even if it was an irrevocable trust. If they're not a current beneficiary, they wouldn't have to report. The belief is that when the regulations are issued out in 2024, that a discretionary beneficiary. So again, if my children were beneficiaries, but only on a discretionary basis, that the FinCEN information would have to be reported. So it's certainly going to change a lot of our trust filings if they own any business interest or LLCs. The same thing if I pass away and I own LLC interest in my individual name, but now I've passed away, so it's owned by my estate. The assumption is that the executor would have to file the FinCEN information. And then the question becomes, what about a trust protector, or what about a financial advisor that's named in a document? Right now, we think that if they didn't have substantial control, or we believe they fell outside that definition, that they would not have to provide the FinCEN information. But we'll find more information, I think, as we get more details with the regulations. There is a belief that a power of attorney likely will be outside that. So even if I have a power of attorney that's operating and running my LLC interest, the question becomes, when does the power of attorney have so much substantial control that they'd have to report? And that's one of those gray areas that we'll get more information on. I think if they're voting the shares and buying and selling assets, likely a power of attorney could even fall within that definition of substantial control. So a lot of changes going on, certainly in the estate planning element. Keep in mind, so a lot of clients like to layer, so they have an LLC that might be owned by another LLC that might be owned by a revocable trust, and then it goes out to 2 spendthrift trusts for the children. You've got to really dig down and get to the individuals that are beneficial owners. So you cannot just say that the owner is this spendthrift trust. You have to dig down, and if the beneficial owners are adults, you'd have to file their FinCEN information. If they're minors, they'd have to find the parent or legal guardian's information. So multiple layers may help you on asset protection and certain other information, but it won't help you from not reporting under the Corporate Transparency Act.
So we talked a bit about the what, the who, the how, the when. So as far as our goals here at the office, and what we'd like to help you all do is we want to identify whether or not your company even is a reporting company, or whether it's an exempt company, and whether it's an active company. And if it's an active, whether we should consider dissolving that company. Educate you guys regarding what's going on, how to stay in compliance with the CTA, and what it looks like in the future, and just provide you with legal services to give you some peace of mind through this transition, because we do understand with FinCEN not having a definitive layout of how this is going to look, what's going to happen with them likely not being prepared to accept these reports. We do understand it can be a bit confusing, you can be a bit anxious about it. We just want to make sure we're there to help you and walk you through this process. As far as what's next, of course, we can't start submitting reports until January 1st, but what we can do is start gathering information. If you are the sole member or shareholder of your company, you likely already have all of the information we need, have that prepared so we can have a conversation about it. If you are not, start talking to the other shareholders or members or anyone else who might be a beneficial owner in the company, whether directly or indirectly, to start preparing them for this. Start gathering the information, start preparing them to file applications for FinCEN identifiers. And then once you get all of that together, let's start talking about a plan of action to draft these reports, make sure that we have all the information we need, and file some timely, true, correct, and complete reports so we won't have any issues.
The IRS and government agencies do a good job of, or they do an estimate of providing how long it's going to take to comply with their reporting requirements. And the estimate is that for each identifier, it'll take 2 hours. That might be accurate, especially at the beginning of this as we work through this, and that it'll take companies between 10 and 11 hours, depending on how many identifiers they are, to comply with this act. So certainly a big burden is being put on corporations. I know Angela's going to be our go-to person. So if you're a client of ours, you can start gathering that information. We'll keep a database because again, there's going to be a lot of gathering that's going to happen in 2024. The sooner the better. Even though we have till the whole year on existing corporations, if you know you're going to fall within the reporting requirements, I hope that we'll start filing some identifiers early in January even, and we anticipate February, March, we'll be doing new corporations on a regular basis pretty promptly, because as we gather information on who's going to be the owners, who's going to be the officers, we'll start also figuring out who we need to provide information under the FinCEN Act. So we'll provide that information and then have a database on it. But stay tuned. It's going to be a different world starting in 2024, at least for corporate transparency. Thank you guys so much for tuning in. Feel free to email Angela or myself with questions. We're glad you took your time out of this busy schedule. We've got Angela's email up here. Again, she's kind of our Manning Fulton go-to person on this matter. And some of the questions we may not be able to answer just because we're still waiting on more definitions, more recs to come out. But we do know January 1st will be our date to start. It's just going to be, and it's likely going to be April 1st is our first reporting that is required. Certainly, we're hoping we're doing some ahead of that time period, but stay tuned. Thank you guys for listening, and we appreciate your time.